This Honorable Court of Appeals of Tennessee is in session. Please be seated.
Good afternoon and welcome to the Tennessee Court of Appeals. We'll take just a couple of moments and run over the ground rules that we're going to follow today before we get started. First of all, most of you are experienced practitioners. I know we've got a few self-represented litigants here today. I want to explain that each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time, but you'll need to request that from the court after you come up and introduce yourself and before you begin your argument. As far as those 15 minutes go, the podium has there's a lighting system on the podium. And the lighting system has a green light, yellow light, and red light. As long as the light's green, you've got plenty of time. Once the light turns yellow, it means you're running out of time. And once the light turns red, you have used your time. We ask that you please respect those time constraints. Also want to share with you that these oral arguments are being live streamed, so just be mindful of that as you make your argument. Our panel this afternoon consists of Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we get started?
No, Your Honor.
Call the first case, please.
Genevieve Thomas versus Cass Clay Thomas.
Are you Mr. Thomas?
Yes.
Yes, sir. Okay. I think y'all are at the wrong table.
We are, Your Honor.
Okay.
Not paying attention.
Well, that happens around here sometimes. All right. We're ready.
May it please the court, I am Noble Grant from the Madison County Bar Association, and I represent the appellant, Genevieve Thomas. This time I would like to reserve 2 minutes for rebuttal.
All right, sir. You may proceed.
So this is a divorce appeal from the Circuit Court of Shelby County, Tennessee. The parties had been married for approximately 30 years at the time of their divorce. And I feel that there were, the matter was more or less a little bit of a mess at the trial level, and the record, from what I glean, has been about the same. But this is a matter that was referred to a special master by the trial court. And that is my first issue, is that was not done properly. As the court is aware, Rule 53 of the Tennessee Rules of Civil Procedure govern special master appointments and proceedings. And those rules suggest that an order of reference be entered that clearly specifies or limits the master's powers. That was not done in this case. Notwithstanding, there was a hearing before the special master, and the special master made certain recommendations to the trial court. The trial court took those recommendations and adopted those recommendations with a few exceptions. But the trial court failed to make any findings that would support its decision to adopt the special master's recommendations. No findings.
Did you object to the appointment of the special master or the lack of parameters?
The lack of parameters is what I take issue with.
Okay. Did you object to that in the trial court or request that?
I do not recall, I was not involved at the trial level. I came on at this level. I do not recall there being any, there was an objection after the special master hearing. There was an objection that was filed by Ms. Thomas's trial attorney about issues with the special master's report and recommendations and the trial court's adoption of those.
Did that deal with the lack of parameters, or did that deal with the substantive findings?
That dealt with the substantive findings, as I recall.
So what is it we can do at this time regarding the lack of parameters for the special master?
So what I would point you to is the Roberts case that I've cited in my brief. This case actually involved the same trial judge as the trial judge in the Thomas case that is before the court right now. And similarly, there was no order memorializing the extent of what, if anything, was referred by the trial court to a divorce referee that was serving as a special master in that case. And that issue was raised on appeal, and this court ended up reversing the decision of the trial court, basically saying that there was no way for a special master to know what the scope of their authority was, with no order of reference that would suggest or give them any direction about what that was. This court, I think, held that there was no way in good faith that the special master could have made any findings or recommendations about what they were deciding without any direction from the trial court or an order of reference to follow to be able to make those decisions that it was supposedly tasked with making. So in reference to that, I would point you to that Roberts case for some guidance on that issue, and that is the main issue of this case. There are also some issues.
Let me ask you a question.
Sure.
On September 5 of 2018, you said you didn't try this case?
I did not try this case.
The wife filed 2 motions, including a motion to reconsider the ruling regarding the marital home, and a motion for a new trial or to alter or amend the judgment, or for relief pursuant to Rule 60.
Correct.
Have any of those motions been ruled upon?
They were not. The wife filed those motions. The trial court subsequently recused itself due to a staff member that created a conflict of interest, according to the trial court. It was referred or handed to, at random, another judge of the Shelby County Circuit Court. When we had a hearing, and I was involved in this part of the process, when we had a hearing on those motions, the new trial court judge said he was not familiar with the facts, did not try the case, felt like the other judge was more appropriate to hear those motions. He did not feel like he was appropriate to hear those motions, so he denied those motions without any explanation other than basically what I just described.
Well, is this a final judgment?
I mentioned that in my brief. I can't really. I don't believe it is a final judgment.
I mean, if the motion for new trial is alter or amend, or for relief pursuant to Rule 60 haven't been ruled on.
They've been ruled on. I just don't think the explanation for the denial is a sufficient explanation.
Well, the judge didn't mention either of these ruling on either of these motions in the order that I'm looking at on September 13th of 21 says the undersigned judge did not try the case, is not familiar with the facts and the parties, and is of the opinion that ruling upon these motions is inappropriate.
Right,
I wouldn't call that ruling on them. would you?
right. I would not.
So I'm just, if we don't have a final judgment, then we don't have jurisdiction, do we?
There is no jurisdiction here. You're correct if it is not a final judgment. I've had concerns about that myself throughout the course of this process. And like I said, I think I mentioned something about that in my brief about it not being a final judgment.
The judge goes on and says that the pending motions are denied in the next sentence.
He does. The motions were denied.
For whatever reason, he just said they are denied.
Right. I don't know that his basis for the denial was sufficient pursuant to Rule 59 or Rule 60, but the motions were, they were denied.
So what's the remedy now, Counsel?
I would say a remand to the trial court. And I think the appropriate remedy would be to give the parties an appropriate opportunity to present their evidence to the court and for the trial court to make findings of fact and conclusions of law in support of a division of the parties' assets and debts, values of the assets, balances of the debts, and findings in relationship to the factors. To decide those, there was also an alimony claim that was not pled, but that was raised, that was never decided, and there was no findings in relationship to an alimony claim. But there are several issues about the division of the assets and debts that was overlooked in this case, and that there were no findings to support. And there's a big issue with the valuation of a pension that belonged to husband at the time, which was the party's greatest asset, their largest asset. And there's no indication of how the trial court valued that pension. According to my own calculations, that pension could be a very valuable pension, somewhere in the range of possibly $1 million. I think the trial court's valuation of it was around $127,000, and there was, again, no finding as to how the trial court determined its valuation. There was, of course, as this court is aware, there are two methods of doing that: the present value calculation and then the deferred distribution method of calculation. And there's no indication as to which of those methods, if either, that the trial court used to value that pension. So to answer your question, I think a vacation and remand to the trial court to be able to address these very important issues that existed at the trial level that were not properly decided, I think that would be the appropriate remedy.
Can that be done pursuant to the motions that you have filed? In other words, we can't tell why the judge, we can read into it why the judge denied the motions, but he didn't give any explanation as to why he denied the motions.
And the motions that you're referencing, I'm familiar with. I do not have them pulled up in front of me, and I cannot remember if either of them, I know one of them had to do with the valuation and the division of the marital home, which is one of Ms. Thomas's issues. I don't remember if either of those motions mentioned the division or valuation of the pension. But yes, it's possible if it mentions the division of the pension, if it mentions the alimony claim that Ms. Thomas has raised in her brief, if it mentions the attorney fee issue, then yes, those could be remedied through those post-trial motions that were not addressed or ruled upon by the trial court. That may be possible. I don't know a definite answer to that question without pulling those motions up and seeing exactly what all issues they raised.
All right. Thank you.
Are you familiar with Rule 63?
If Your Honor will let me know what that rule is, as I do not have it pulled up in front of me.
Well, I'll let you take a look at it, and we can discuss it when you come back on your rebuttal. It's,
Okay.
Tennessee Rules Civil Procedure 63. I'm curious as to how its application works in this type situation, if it in fact does apply.
Sure thing.
Okay. Thank you.
Thank you.
Hold on, Mr. Thomas. Mr. Thomas, you're representing yourself, is that correct, sir?
That's correct.
Okay. Let me just sort of reiterate what we mentioned before. You've got 15 minutes to tell us anything you want about this case, okay? And that monitor right there is the one that I was referring to a moment ago. After we hear your argument, what will happen is Mr. Grant will come back up. I think he's got 2 or 3 minutes of rebuttal time, and he'll tell us whatever he wants. We won't render a decision today. What we will do is we will review the record, we'll do the research, we'll write an opinion, and you'll get a copy of the opinion when we decide the case.
Okay.
Okay? Have any questions or anything before you get
I do
started?
not.
All right. You may proceed then.
Okay.
If you will, go ahead and tell us what your name is, just because we're recording all this as well.
Okay, I'm Cass Clay Thomas, and this divorce, I know he referenced, well, I'm gonna go on my thing. This divorce was 9 years long. It started in like 2013. Actually, it was actually 3 cases. She filed her first case, and then when we went to court back in 2013, she decided that she was gonna drop the case because the judge told her to bring all the information in with her bank statements. So she non-sued and canceled that case. She filed another one in 2014. After 7-8 months of court, she canceled again. And because I think it was Judge Jimmy Bailey back then, he told her to bring all the information in, you know, on the court documents and her bank statements and all, so she canceled that one. But the reason for this divorce was like in 2013, I found out my wife was stepping out on me or whatever. And so in order to, I guess, save face, she filed for divorce and left me and my 15-year-old son at home. And she moved with another guy, and then she filed 3 divorces. This third divorce in question went to court August 28th of 2017 after 2 years of going back and forth to court. August 28, 2017, went to court, and we was in Judge Hurd court, and she told us to come back to court with all details of all our debts and, you know, all the debts and all the everything we owe. So we get back in court on August 28th. I guess I say the ex-wife, she didn't agree with anything. So we got in court like 1 o'clock. It's like 5 o'clock. She still wouldn't agree with anything. So Judge Hurd sent us back to the back chambers. So y'all go back there and y'all work it out. Work out the details. I'm gonna divorce you all today, but work out the details. We go back in the back for 3 hours. She don't agree to anything. So she said, Miss Thomas, I don't have all this time to sit here and argue with you in court back and forth, and because I got other trials. So she never did agree to anything. So the judge, she gave us the rules on what the special master was going to do. Special master was going to go over your household debts and this and that. And like I said, this divorce went through 4 courts. We started off with Judge Corbin, and she gave my ex-wife an alimony payment because she was living in the house. She moved in, and she was moving in and out, moved with the guy, moved back while I'm at work. So Judge Corbin told her, said, you know, I want you to pay half of the household bills until we divorce. They gave her alimony payment. She did not make those payments. I mean, she made the payments, but she took her debit card and went back to the bank and got it out. And I think that's part of the records. That's exhibit. It's exhibit volume 1, exhibit 6. She put $1,000 in the bank. They told her $2,000. Then they pleaded with her and got it down to $1,000. She put $1,000 in, and then she went and got $1,000 out by the time the month was in. And what she was doing with that money, I don't know. But and then they charged her with contempt of court. Like I said, she was very difficult during the whole time. They charged her with contempt of court, and then they said she had to pay the money back from, not paying the money. I'm gonna try to move because I got all the time. But anyways, to move forward, when he said the case was not heard, the case was actually heard 5 times by different judges. Judge Corbin first gave an alimony to the wife for $1,000. We got the Judge Heard court, and I'll give you the dates. Like I said, August 28th, we had the trial. Judge Heard court. The wife wouldn't agree on anything, so she divorced us, and she settled what she could, and she told us she got 6 to 7 months to get all your information together, all your details on what's your debts, and who you owe, and all that, and come and go to the special master hearing. She gave all this to us in a written form. I think it was volume 1, page 42. She actually told us exactly what we need to do when we go to the special masters. The wife got all the pension numbers and all the information, and she brought it to court. And that's going to be exhibit, volume 5, exhibit 14, Genevieve adjustments. So went to special masters 6 months later, or 6, 7 months later. On March 27, went to special master court, had a special master hearing. Special master ruled, and she had 10 days to appeal or object to the special master ruling. She didn't make the 10 days. She appealed July the 27th, which is more than 60 days later. My attorney, she brought him in court. That was way too late to appeal the special master hearing. But Judge heard the case again, and then she ruled again. Volume 1, page 85 through 87, she ruled again on it. She denied it. And then she made a final judgment. Well, my wife, like I said, my ex-wife, she don't like to take no for an answer, so she went and hired another attorney. She brought another attorney to court, and they filed a motion to have the case heard again. Then on September the 6th, Judge had heard the case again. She denied it. It's in the records. So she wasn't happy with that. This was in 2018, September 6, 2018. Then she wanted Judge Heard to hear the case again, her new attorney. But Judge Heard said she had heard the case, and she had made a decision on it and waived it. And and then in March, they transferred it to Judge Russell's court. The reason they did that because Judge Heard hired her attorney's daughter to be her clerk. And she would actually send the information out to me on the case, so she had access to the records. So they moved it to a different court. They moved it to Judge Russell. Judge Russell had a hearing by phone during COVID, and he said that it was inappropriate for him to rule on this case again that's already been heard, ruled, and waived several times. So he said it was inappropriate for him to rule on it when it had already been heard and ruled. And then, like in appendix in my brief, in appendix A, it kind of give you like the details of the debts and what we owe and this and what we owe and the debts and the bills we owe and all that. Let's see where I want to go with this. In the special master's assignment, she gave us assignment. She said for like the cars, the vehicles, she divided the vehicles. She gave my ex-wife $14,000 worth of cars. She gave me $6,000 worth of cars. The $14,000 worth of cars that she gave my ex-wife are still in my yard right now, 5 years later. And when I sent her certified letters, I had my son take the keys to her, and she said, I don't want them. So she went out and bought new cars. She went and bought her a new Mercedes-Benz with a new man, and she went out and bought her a new Range Rover. And those cars, like 5 years, my homeowner association been telling me, get the cars out the yard, get the cars out the yard. The car's still there. And when she filed this appeal, she showed up for the first time in 5 years with police saying she wanted the cars. I gave her the keys. She had no drivers. She was by herself. She was parked down the street. I hadn't touched the cars in 5 years, so they won't run. But she left. The police said, well, you should have got these cars 5 years ago. I think I think you were late on your court order. So she didn't get the card. The card's still there. They were there this morning I left. She didn't get the card. And also, the special master said for us to divide the furniture. To divide the furniture, she said, you pick one. It said in special masters, I got the date in the page to find it on here. While I was at work, she got two big, I guess, 18-wheelers or whatever you call them, and took all the furniture out the house except for like a den couch and the master bedroom. And when I get home from work, somebody said, you moving? And I said, I'm not moving. They're like, somebody moving. And I go there, I got one truck full and the other one half full. We supposed to pick one, and to pick one, she picked one. So she's not following any of the court rules. But then she called the cops, and the cops said, well, we can sell it in court or, whatever we need to do. So I let her take the furniture. The car's still in my yard. She was arguing about the house, and she moved one block over from me in a house for $325,000. Her and the same guy. And she bought a house there about 2 years ago. So she drives past my house, she takes it as some kind of joke or something like, like I got you. I'm gonna take everything you got. And the numbers we use to calculate, distribution assets was all the numbers that she gave the courts. And if you look at the numbers that they used, they were actually all her numbers. When you look at how it was calculated, when you look at how the pension was calculated, how the house, in volume 1, exhibit 14, it's Genevieve adjustments. All the numbers that the court used were her numbers. We both work for the same company, MLG&W. I have a pension, she have a pension from MLG&W. She got all the information from personnel, she worked in HR, and she turned all this into the court. I agreed with the numbers to get the divorce over with and move on. But and like they said before we came to appeal court, my attorney, she spoke and she said, she argued her own numbers. These numbers are her numbers. If you look at what the court value, the furniture, the value of the house, it said purchase price, but that actually is the equity in the house. The court valued at $85,000, she valued at $79,000. I agree with it. I gave her what the court said, $85,000, gave her $42,000, because that's the number that she brought to court. I agree with it. But like I said, all these numbers are her numbers. And like I said, if you look at volume 5, exhibit 14, and you can follow her numbers straight down the page, Genevieve's adjustment, she adjusted the numbers from August 28 into the special master hearing. She brought it to the special master hearing, laid them on the table and said, here's the numbers. And the judge went straight by her numbers. And later on, like 2 years later, she decided the numbers weren't good enough and she wanted to change the numbers. But all that information is in my brief. And like I said, I still want to say again that this is the third divorce case, and I spent a lot of money on attorneys because she filed, and we get a hired attorney, we go to court, then she changed her mind and said, because she don't want to do what the court says. She had, during our court, trials, she had two contempt of courts. In special master hearing, the judge said, the special master said, if you put money in this account again and take it out again, I'll make sure you spend some time in jail. So, I really don't know what else to do. I moved on, and, found a new wife, so. But like I do want to say, this case, it had been heard not at least 4 or 5 times. We've been, like I say, Judge Corbin heard it, and she did an alimony. Judge heard it on the 27th. Then, on the August 28th, the special masters heard it, and then we told them, her attorney said she had 10 days to appeal it. To object. And you look at it, she didn't object to July the 10th from a March 27th date. She thought about it, I guess, and then she objected way late. My attorney said, you didn't have a right to object after 10 days because the rule, I guess it's Rule 5304. You got 10 days to file a written notice that you object to the special master's hearing. She didn't object to it. And now, like I said, we've been divorced since 2017, this 2022. And she's still fighting the same battles. And like I said, we're still arguing about her numbers. We're still arguing about the cars in the yard. She has purchased a new house, new cars, and still, the cars that they awarded her are still in my yard. Homeowner Association trying to, charge me a fee for having them. I have, tried to reach out to her, had my attorney to reach out to her attorney. But for some reason, she felt like if she just go get another attorney and go to another court, she would get the judge to overrule the other judge. And this has been going on since 2013.
All right, sir. Thank you.
Thank you.
I think you got 2 minutes, Mr. Grant.
So I did have a chance to look at Rule 63, and I'm happy that you pointed that out. I do believe it does have some application to the case at bar. Once the trial court recused itself and the other judge was selected to hear the matter, I think the record is devoid of that other judge certifying familiarity with the record and determining that the proceedings in the case could be completed without prejudice to the parties. Quite conversely, he acknowledged his lack of familiarity with the case. So that would certainly be relevant to everything that happened after the court recused itself and the other judge stepped in. So I do believe that Rule 63 would definitely be applicable and would be another error in the trial court's handling of the case. And outside of that, I rest on my brief and the lack of authority that is relied upon in the appellee's brief in this matter. There was very little law that was relied upon in that brief. There were also several documents and facts and allegations within the brief and appendices to the brief that were outside of the trial court record. And I would ask that this case the trial court's decision be vacated and this matter be remanded to the trial court to revisit the issues that have been raised on appeal and for appropriate findings of fact and conclusions of law, division of assets, debts, and the appropriate addressing of claims that were raised in the trial court.
All right, thank you.
Thank you.
Mr. Thomas, as I say, we will take this matter under advisement. We will file a written